So here is the slide that we have prepared for writ jurisdiction. Okay, just 1 second. Okay, fine. Now when you will see that we are talking about writ jurisdiction, you will also find out there are certain things, okay, that writ jurisdiction basically deals with that what kind of writs are present in our constitutional structure. Okay, so let us start with the definition. So we will proceed with the definition. We'll try to define what writs are, and then once we are done with the definition, we'll try to understand its various aspects. Okay, and then how it is exercised. Okay, and then we will end this discussion over here. Right, so let's start. So when we talk about writ jurisdiction, what is important is to have in mind. Just 1 minute, guys. Okay. Now, what are writs? So when it comes to asking that what writs are, basically, writ is nothing but an order. Okay. So if there is a written order by the court, so court ने क्या किया? Court ने एक order लिखा. Court gave you an order कि ऐसा ऐसा चीज होना चाहिए, right? And then you started discussing about it. Okay. So when you start discussing about it, so जो एक order है उसका जो primary function है वो ये है कि you should be able to implement it, right? So जो कोई भी order है उसको हम सबसे पहले क्या करेंगे? Implement करेंगे. So ये जो कोर्ट के orders हैं, they are basically meant to basically just give me a second. Right. So when we talk about order, so these are the orders which are provided by a court to a lower court or authority. Right. We have talked about this. Now, when we talk about a lower court or an authority, apart from this, what is important is that it is basically a direction. So जो higher court है, let's say कि Supreme Court है, वो नीचे के authorities को, now authorities पर केवल और केवल court नहीं है. So we are not talking about let's say कि High Court जो है, Supreme Court जो है वो High Court को कोई direction दे रहा है. इसके अलावा हम लोग ये भी बात कर रहे हैं कि जो Supreme Court है वो other authorities को, authorities can be district magistrate, okay, authorities कोई और भी हो सकता है. तो इनको ये proper direction दे रहा है, okay, किस लिए कि आपको ऐसा कुछ करना है. नाउ ये जो पूरा का पूरा कंसेप्ट है ये कहां से स्टार्ट हुआ? ये इंडियन कॉन्स्टिट्यूशन से स्टार्ट हुआ, इंग्लैंड से, राइट? इंडियन कॉन्स्टिट्यूशन में इसको लिया गया इंग्लैंड से. इसके बाद हम लोग देखेंगे कि जो रिट ज्यूरिसडिक्शन है उसको इंडियन कॉन्स्टिट्यूशन में आर्टिकल 32 और आर्टिकल 226 में डिफाइन किया गया है. या जो पावर है रिट ज्यूरिसडिक्शन की वो सुप्रीम कोर्ट के पास आर्टिकल 32 के तहत है और हाई कोर्ट के पास आर्टिकल 226 के तहत है. अपार्ट फ्रॉम दिस, व्हाट इज द प्राइमरी एम? So when you will read about Article 32, the heading of Article 32 is right to constitutional remedies. Okay, so it basically talks about कि हमारे पास constitutional remedy क्या है, what are the provisions जिसको use करके आप let's say जिसको use करके आप आगे बढ़ सकते हैं या जो आपके remedies में काम आ सकता है. Now when we talk about remedies, what we are talking about is कि जो हम लोग बात कर रहे हैं, let's say constitutional remedy. What is remedy? Remedy is कि if you are aggrieved, if you are aggrieved means आपके कुछ fundamental rights हैं. Let's say you have right to free speech, but your right to free speech is not getting to you. और आप कहीं आप कुछ बोलना चाह रहे हैं, but somebody is trying to suppress you. Okay, let's say you wrote something, a piece of article, और लोगों ने उसको publish नहीं किया, and even if it was published, it was highly criticized and ultimately it was withdrawn. So if such things are taking place, what we are trying to understand is if such things are taking place, the primary aim is कि जो रेमेडी है, so let's say there are certain laws related to these. तो आप कुछ laws हैं, let's say कि nobody can suppress the freedom of press, but somebody is trying to suppress the freedom of press. Such situations are going on in Jammu and Kashmir, जहाँ पर हमने special provisions बना दी है. और अब at present जो freedom of press है वो वैसी नहीं है जम्मू एंड कश्मीर में जैसी होनी चाहिए, right? या फिर let's say कि उनके पास free internet नहीं है, they have internet access of 2G speed, which restricts a lot of things. Right? So what we are seeing is कि ऐसे situations में court can order the authorities. Now what are the authorities? Authorities can be the high court situated in Jammu and Kashmir, or it can be, let's say, the Indian government, right? So basically, a person or an authority who is responsible for snatching a right is basically ordered under the writ. Okay, so writ के तहत जो कोर्ट है वो क्या करेगा, वो जो अथॉरिटी आपकी राइट्स को सप्रेस कर रही है, उसको दबा रही है, उनको वो ऑर्डर देगा. सो रिट इज नथिंग बट अ रिटन ऑर्डर, राइट? नाउ क्वेश्चन ये आ सकता है कि सर वी ऑलरेडी कॉल, हमारे पास ऑलरेडी एक टर्म है ऑर्डर. ओके, नाउ जब हमारे पास ऑलरेडी एक टर्म है ऑर्डर ऑफ द कोर्ट, तो फिर हमको रिट की क्या जरूरत है? तो फिर रिट कैसे अलग है? टू अंडरस्टैंड दिस वी नीड टू अंडरस्टैंड दैट रिट्स आर मेड फॉर स्पेशल पर्पसेस, राइट? और जो रिट्स हैं, बेसिकली रिट्स कैन नॉट बी ignored. You cannot ignore a writ. Okay, so जो writ हैं, ये these are special instruments, these are special legal instruments. Okay, so you can write it over here that writs are special legal instruments, okay, generally. But when it comes to Indian Constitution, writs are provided under Article 32 and Article 26. Article 32 provides writ jurisdiction to Supreme Court. Article 226 provides writ jurisdiction to High Court, right? Now this is something that you need to have in mind. Okay, now scope of writ jurisdiction. Now when we talk about the scope of writ jurisdiction, what we are trying to understand is कि writ jurisdiction को हमको कैसे use करना है, how we can use it. Now we have used the general term writ. Okay, now I am just introducing a new term which is prerogative writs. Okay, now prerogative writs are nothing but a subset of writs. So let's say what are writs? Writs are written orders. Now prerogative writs are special orders or extraordinary remedies for an aggrieved person. तो जहां पर भी extraordinary remedies के बारे में बात आ रही है, वहां पर कोई aggrieved person आ जा रहा है, तो हम लोग aggrieved person के बारे में अब यहाँ concerned है कि जो aggrieved person है उसके साथ क्या हो रहा है, right? So basically prerogative जो term है that implies कि अगर कोई person aggrieved है, अगर उसका fundamental rights उसको नहीं मिला है, तब रिट्स का इस्तेमाल किया जाएगा. ओके, एंड देयरफॉर आई एम सेइंग कि इस केस में, इंडियन कॉन्स्टिट्यूशन के केस में, रिट जुरिसडिक्शन इज द काइंड ऑफ प्रेरोगेटिव रिट जुरिसडिक्शन. Again, we have mentioned this that it is provided under Article 32 and 26. Now it is a discretionary power. Now when I say discretionary power का मतलब है कि हम लोग किसी चीज पर डिसाइड कर सकते हैं कि नहीं कर सकते हैं. So if you have so let's say I ask you that you can decide as per your discretion, then what we are trying to say is कि you have your own capability to decide on something, then you need to decide on something and then come up with it. Okay, so in this case, when we say writ jurisdiction is a discretionary power, we are saying कि Supreme Court and High Courts which are exercising writ jurisdiction, they have the freedom to decide that whether they wish to, let's say, issue a writ or they do not wish to issue a writ. So it depends on them. It does not mean that anybody who approaches the court with a writ, okay, gets approved. It is not so. It is ultimately on the discretion of the court. Okay, so in this case, Supreme Court and High Court. So Supreme Court and High Courts will decide how they need to take this up. Ultimately, under Article 32, now this is not under writ jurisdiction, but when it comes to Indian Constitution, we need to have an overview कि Indian Constitution में writs की क्या importance है. Now ये जो power to issue writs, okay, this is provided to Supreme Court and High Court. We have talked about the related articles. Now apart from this, Parliament has the power to give this power to issue writs. Okay, so let's say Parliament can authorize a third court, which can be any court, which can be a tribunal, okay, to issue writs, right? But we need to have in mind that in such cases it cannot be against, or it cannot be prioritized against the Supreme Court. So let's say any other court cannot have more powers than Supreme Court. In other words, so Parliament can provide more powers or more power to issue writs to any other court, but it cannot take away the power provided to the Supreme Court under Article 32 to issue writs. ठीक, तो हम लोग इस बारे में चर्चा कर रहे हैं. Although we will see all of these in detail when we will start, let's say, talking. So we will see all of these in detail, right? There is one more question, sir. Why is Article 32 called as heart and soul of Indian Constitution? Muzaffar, we will come back to this discussion. This is already included in our slide. We will come to this discussion by the end of the slide. Okay, so just have certain patience. Okay, I guess we will be there in 10 minutes. Okay, the class is not that long. Okay, now let's move to the other aspect. Other aspect is saying key suspension. So when can writ jurisdiction be suspended? So writ jurisdiction can be suspended only in one case, when you have national emergency in place. Now national emergency can be declared by President of India. Now this provision is under Article 359. So these things are, I'm just giving you an outline. We will talk about all of these in detail in subsequent classes. Now there is one more term which I am introducing it over here, which is saying prerogative writs as extraordinary writs, right? Now the term extraordinary writs simply means that it is not so that any person at any times can approach the court and can ask the court to resolve the matter using the writs. Why am I saying this? Is because under Indian Constitution it is extraordinary. Although I have written it over here that it is not extraordinary for fundamental rights, but there are certain rules which Supreme Court has set. Okay, when it comes to issuing a writ. Okay, so let's say that some of your fundamental rights are violated, and you approach the Supreme Court directly. Okay, now the question arises: can you? Okay, the answer is yes, you can. Theoretically, you can, because that is the right provided under Article 32. Okay, but practically, Supreme Court has let down the precedents or the set of rules, or it has set up the guidelines that when can one approach directly to the Supreme Court when there is violation of, let's say, fundamental rights. Right now, these rules are known as rules of exhaustion of remedies. Right. So it is saying that when none of the remedies are left, okay, to be exercised, only then you are allowed to directly approach the Supreme Court or High Court. In other cases, one should go through the general procedure. So one should file the case in general courts, and then the courts should move on. Right. So that's the process. So one should not ultimately file the writ petition. Rather, they should file a simple case. Okay, and then the court can decide that whether writ petition is required or not required. So this is one aspect of the whole discussion, and therefore the term extraordinary becomes quite important over here. The extraordinary in this case means that whenever the alternative remedies are exhausted, only then they can be exercised. So that is extraordinary, means when all other remedies are left. Like these days in newspapers, we are hearing the term extraordinary times. So these are not general times. Similarly, extraordinary writs means these are those orders which are issued when all other orders or all other means to approach the court has been tried, or let's say is not in place. So there can be certain cases when there are no concerned laws related to it. So when such cases are there, then we will call then writs can be issued, and therefore these writs are called as extraordinary writs. Now I have mentioned the two cases over here: Union versus T.R. Verma case, okay, and then Tegahur paper mill case versus State of Orissa. We will be talking about these cases, and then we will talk about rule of exhaustion of remedies in the regular classes. I'm not picking up these rules right now, okay, just to keep the demo simple. Right now, we need to talk about the types of writs. Right, so we have habeas corpus, we have quo warranto, then mandamus, certiorari, and prohibition. Right, so we will talk about all of these one by one. Okay, so let's see what habeas corpus means. Habeas corpus is nothing but it means habeas corpus is you have the body. Right, so when we talk about habeas corpus, what is the discussion is that somebody, see, there are two terms that we will be using: habeas corpus general, and then we have the term habeas corpus sufficientium. Right, so what is habeas corpus? So you have the body, that is the general translation from Latin of habeas corpus. The general meaning is that whenever there is illegal detention, so this particular writ is issued in cases related to detention or imprisonment. So let's say right now there are, or let's say there were several political prisoners in the state of Jammu and Kashmir, right? So in this case, one can ask, or let's say Supreme Court can issue the writ and can ask the detainee or who has detained these political prisoners. So let's say if Mehbooba Mufti is under arrest, okay, one can file the court in Supreme Court, okay, under writ. So they can ask for a writ. And if Supreme Court issues the writ, what it is doing is it is asking the concerned authority, in this case, the concerned authorities in Jammu and Kashmir or government in Jammu and Kashmir, to come and prove the legality of detention, right? So who is liable to prove the legality of detention? The one who has detained, right? So in this case, the government of Jammu and Kashmir has detained some persons, and if court issues the writ related to these, okay, or issues the writ of habeas corpus, okay, and then in that case the government will have to come up, or will have to present itself before the court, and then it will have to prove that why the detention that it has done, is it legal or is it not legal. Now let's say the court finds that the detention in this case is illegal, then in this case the court will issue another writ, which is habeas corpus subjudiendum, right? Now habeas corpus subjudiendum means that to immediately release the person who has been detained. So let's say if Supreme Court, if somebody went to the Supreme Court and filed a habeas corpus writ, okay, and Supreme Court accepted the writ, and there is complete procedure over there, or let's say there are cases, so the gender proceedings moved ahead, and Supreme Court found out that Mehbooba Mufti or any other political prisoner of Jammu and Kashmir has been illegally detained. Then in this case, Supreme Court will order a next writ, which is habeas corpus subjudiendum, which will mean that in this case, the government, or which is the detainee, will have to release the prisoner right at that particular time, right? So habeas corpus basically deals with the cases of illegal detention, right? This is something that you need to have in mind. Okay, now we will again talk about certain cases which are related to this, but not in this class. We will discuss those in regular class, right? Now let's move to this quo warranto. Quo warranto means by what warrant, right? So the very term by what warrant means, इसको सुन के ऐसा नहीं लग रहा कि somebody is asking the question, right? So when somebody is asking the question, one should get this in mind, that a court is asking a public office, okay, about the legality of something, right? So if somebody is holding a public office, जैसे कि आप कह देते हैं कि आप गलती से आप या फिर आप कलेक्टर बन गए हैं किसी जगह के, but you do not possess the right qualification, or let's say a DM is also holding the post of deputy DM at the same time, okay, then in this case court can inquire the legality, that why a person is holding two public office at the same time, right? So this is nothing but a question which is there when it comes to asking for the legality, and it relates only to public office. It will not relate to private office. Now what is public office? Public office is one which is created by a law or a statute or by Constitution of India, right? So public office is one which is created under a law or a statute, or there is the provision of such an office under Constitution of India. Again, we will talk about all of these in detail, right? So basically what you need to remember in this is that it is nothing but asking of the legality of a claim of a person who is holding a public office by a higher authority, which generally is a court, right? Okay. In case of Jammu and Kashmir, there is always a violation of fundamental right. Why so? Muzaffar will talk about these. We have a separate time for discussion. We will pick these questions at the end, right? Just give me, we have a few more slides to go, and then we will start the discussion, and then each and every one of you can ask the questions, right? In the meantime, you can type your questions, you can have them ready, right? So we will start with your question. Okay. Now let's move to the next one. Mandamus or we command. In this case, a public official is commanded by the court, which is, let's say, it can be Supreme Court when it comes to a public office related to central government, and it can be High Court when it comes to public office related to state government. Okay. Now it is just asked for a public office to perform their duties. So let's say if DM is having the responsibility to maintain law and order, okay, in certain areas, okay, or in his district, and if somehow he is not able to perform it, or if he is not paying attention to those things, then in that case court can ask him to perform his duties well, right? And in this case you cannot ask the DM to perform certain actions which are discretionary. So let's say if there is, it is on the discretionary power of DM, let's say when to hold a meeting. So if it is holding he or she is holding a meeting, a public meeting on let's say Monday, and he or she decides not to meet on Tuesday, so it comes under his discretion or her discretion, then such things which are under his or her discretion cannot be asked, right? So public official, so they will perform their duties, but if the duty is general, or if it is well defined, only then that can be questioned. In other cases it cannot be questioned. Similarly, one can easily confer from this discussion that mandamus cannot be issued for a private individual. It cannot be issued against you and against me, right? Next is we have prohibition. Prohibition is nothing but to forbid. Okay, to forbid means to have a tap on something, to restrict something, right? So if you will notice the pattern that we have, okay. So in mandamus, the court is asking a public authority to perform their duty, okay, and in prohibition, they are asking a authority, which basically is a judicial and quasi-judicial body, not to perform certain certain exercise or certain duties or certain actions, right? When this will happen, whenever there is excessive jurisdiction. So let's say High Court has the power to decide the cases of a state, okay, or related to its state, but High Court has picked up a case which is not related to that particular case. So let's say the High Court of Delhi has picked up the case related to Chhattisgarh. Now it has no connection with Chhattisgarh. Then in this case, this will be an over exercise of jurisdiction of Delhi High Court, and then Supreme Court can order or can issue the writ of prohibition and can prohibit the High Court of Delhi from taking up those cases, right? So this is to prevent excessive jurisdiction, right? Which our authority is not having. So when I say quasi-judicial bodies will include certain other bodies. They can be tribunals, they can be other law enforcing agencies. Okay, so all those authorities which have certain power to decide. Ultimately, the last one is certiorari. Certiorari is to be certified. To be certified means court is generally asking the information, right? So let's say if there is a case which has and there is a judgment being made in a case, and the High Court feels that this particular case was beyond the jurisdiction of a particular court, right? So in this case, the High Court or the higher court, okay, which can be Supreme Court or High Court, can transfer this case from the lower court to itself, right? So it will say कि ये जो court है, ये जो case है, ये आपके purview का नहीं है. We will pick up this particular case. Now, when this can happen in lack of jurisdiction, so if you do not have the authority of taking up the case and you do it, that is certiorari. When there is excess jurisdiction, again that is there. And then when there is error in judgment, right? So error in judgment मतलब सुप्रीम कोर्ट को लगता है कि किसी फैसले की जो सुनवाई है या जो रिजल्ट है वो गलत आ गया है. So if there is wrong judgment, then in that case certiorari can be used. Similarly, I have just mentioned it over here that it deals with transfer of the cases to itself or squash the order or judgment, right? So we have talked about it. Now, okay. Now let's move to the conclusion. So let's just conclude the general thing that we have discussed. Number one is you need to have in mind. See, one more thing that we'll be talking about all of these in detail. We haven't discussed about a lot of things that a certain writ can be issued against which authorities, and which authorities are outside the purview of certain writs. We haven't discussed that, so we'll be discussing those questions. Similarly, we'll be discussing all the writs in details. We'll be discussing Article 32, Article 226, all in detail. Okay, but I will pick up the questions, and therefore I'm moving towards the conclusion. Now, one can always ask that what is the purpose of writ? कि writ की जरूरत क्या है? Okay. So when we see कि writ की जरूरत क्या है, so the ultimate purpose of writ is to provide swift judicial review. Okay. Swift judicial review मतलब किसी को आपने कैद कर रखा है, somebody is arrested, okay, and somehow their case is getting delayed. So one can approach the court directly because it deals with the fundamental rights, and then court, if deems or if let's say court feels that it is important to take up this writ, court can take up that writ, and then judicial review can be done, right? Similarly, it upholds the principle of justice and democracy. There is a famous quote: justice delayed is justice denied. Okay, so as we are accelerating the process, or we are trying to make this complete judicial review a swift process, therefore the justice is ensured on time, and therefore the democratic values also remains well in place. Similarly, it is used to enforce fundamental rights, and therefore it becomes a weapon, or let's say a handy tool when it comes uh, to people in general, where they have their right. So ultimately they have their right for other rights. Okay, so basically Article 32, which is providing the rights, also protects other rights. Okay, similarly we have controls actions of administrative bodies, right? So we have seen that in Mandamus the court is asking that how a particular public office is exercising greater jurisdiction and such things, right? So ultimately it is trying to control administrative bodies. So this is the general outline. Of course, this is a much bigger topic and it requires greater discussion, but we will do that in the regular course soon, right? Okay. Now there is a question for your ready reference. Okay. So the question is: mandamus cannot be issued against. Read the question. Okay, and you can answer. So why I have put this question over here? Just to give you a picture what type of questions are basically asked, right? So such type of questions can be asked. Okay. No, now one can always ask कि इसका actual answer क्या है? So we will talk about these, right? Fine. So just okay. President. Muzaffar has answered president. Okay. Okay. Fine. See, the answer is 2, 3, and 4. It cannot be issued against private individual. It cannot be issued against Chief Justice of High Court because he is acting in his judicial capacity, and at the same time, it cannot be issued against President of India. Right? So, President of India is quite obvious. Okay, Chief Justice of High Court can become confusing because sometimes we have seen that how Supreme Court and High Court are related. Okay, so that can be confusing, but it will be rectified over time as we will talk about other aspects. Similarly, we have private individual. We have already talked that mandamus cannot be exercised against private individuals. It is exercised against public offices, right? So that we have discussed. The right answer is 2, 3, and 4. B. Okay. So such questions will be asked, and we will be taking up these questions in the classes, and then we'll be moving ahead. Okay. So let's start with the question session. You can ask your questions. Okay. Tomorrow we'll be having this session. Before I take up the questions, it is important to let you know that tomorrow we'll be having the session at 7 p.m. It will again be a demo session, and we'll be discussing one more topic. The details of the topic will be available to you. Okay. Yeah, Muzaffar, they are confusing. Okay, we'll pick your questions, right? So these are the queries. So if you have any query, you can send them to these details that we have provided over here. So I'm going to stop the share, and then we'll be picking up the questions, right? Okay. Fine. Now let's see what questions we have. Okay. So we have one question, sir. Why is Article 32 called as heart and soul of Indian Constitution? Right. Now, Muzaffar, if you can recall Article 32, Article 32 basically talks that courts have certain power to issue writs, right? When fundamental rights are violated. Okay. Now, when fundamental rights are violated, you have another right to protect that, right? So, in absence of Article 32, the protection to other rights goes away, right? And therefore, you can call it as soul of Indian Constitution because it is protecting other rights, right? So basically, it is called as cornerstone of Indian Constitution because the very idea of rights has the basis on it. So if you define rights, what are rights? If you try to define it, rights basically are nothing but social claims. Social claims are those claims which are for the betterment of the society, or which are not against the society. So let's say your claim to commit suicide is not a social claim, but your claim to have education is a social claim, right? So social claims are those claims which are for the welfare of the society, right? So rights are basically social claims, but all claims are not rights. For a claim to qualify as right, what is important? That it should be protected by certain laws, right? Now, if there is no law to protect or to provide a protection to a certain provision, then in that case, you don't have the right for it. So let's say we can talk about that you should have right to privacy. Now, if there is no law to punish somebody who has violated your privacy, then in this case, you do not have the right to privacy. You can talk about it, but you do not have it in actual sense, right? So what are rights? Rights are social rights which are protected by the state or by certain laws. And in this sense, Article 32 is protecting all other rights. So whatsoever rights you have from Article 14 to Article 35, okay. Of course, Article 12 and 13 are also are included in Part 3, but they are the definitions, and therefore I am omitting them, right? So whatever rights you have from Article 14 onwards in Part 3, okay, all those articles are somehow will lose their teeth, or they will lose their implementation if Article 32 is withdrawn, right? Because if any article, or let's say if any right is violated, you should have a way to approach the authorities, and Article 32 provides you that, and therefore it becomes the cornerstone for all other rights. We have next question which deals with in case of Jammu and Kashmir, there is always a violation of fundamental rights. Why so? See, in case of Jammu and Kashmir, there is always a violation of fundamental rights. That is not so. I will not stand with this statement. Okay, but I will definitely say that okay, there are instances where there are violations. Now you need to understand one thing when you are talking about rights. That rights are coupled with duties. You cannot try to have rights without performing your own duties. Okay, so if in any situation, let there be any society, let it not be Jammu and Kashmir. Let it be any situation. Let it be Chhattisgarh where you have the problem of Naxalism. Let it be Northeast where you have certain extremist movements going on, right? So at those places, fundamental rights are of course violated at certain times. And when it is violated, we need to have this in mind that fundamental rights are not absolute. They can be withdrawn, and they are definitely not absolute when you are not performing your duties, right? So citizens cannot just keep on asking for rights without performing their duties. So when it comes to Jammu and Kashmir or any other regions where you find frequent violation of fundamental rights, one should always see that are there proper abiding or proper abiding of the laws. Are citizens following the laws, or they are not following the laws, or are they fulfilling their duties towards the state or not? Okay, because it's a two-way process. You cannot just demand the rights and not perform or oblige to the duties that you have towards the society. So it's a two-way process. So we'll discuss all of these in detail. Okay, but I will say that I don't stand with this statement that it is violation of fundamental rights, because as far as I think, the notion is that Indian government keeps on tries to set up law and order, but ultimately law and order is distorted somehow. I won't blame either the people in Jammu and Kashmir or the government, but somehow there are certain forces which disturb the law and order, and in that case, maybe the fundamental rights are violated. The way Mehbooba Mufti has been put under detention, of course, is a violation of fundamental rights. But again, we need to see that those are not general circumstances, rather they are extraordinary circumstances and situations, and therefore we need to have a special attention to that. Right. Next, we have president, sir, district magistrate, judge is equal to judge. So confusion. No, Muzaffar, district magistrate is not equal to judge. Okay, because again we will talk in polity that there should be a clear distinction between an executive and a judiciary. Right. So earlier this was the case where district magistrate used to be judge. Now, see, district magistrate has certain judicial functions, but it is not just completely judge, right? So there is separation of power. So it is he or she is more of an executive than a judge, right? So this is something that you need to have in mind. So if somebody asked what DM is, DM is basically a part of executive, right? So he or she is a permanent executive. Okay. Next we have yeah. Any other questions from anyone else? You can unmute yourself. We have AS Gaur, we have Rashid. You people can unmute yourself and then you can easily ask the question. None? Quick question hai?
Sir, why the government removed the article number 370 from the Jammu and Kashmir, sir?
I didn't get your question clearly. Can you please repeat it?
Sir, why the government of India removed the article number 370 from the Jammu and Kashmir?
Why was it removed, right? See, why was it removed? Because they wanted to do that, of course, and they wanted that state should not have special provisions, right? But one can again argue that there are certain other states which are having special provisions. But you will see that there was no other state which was quite as independent as Jammu and Kashmir, having a separate constitution and all, right? So removal of 370 was kind of giving a message to the people in Jammu and Kashmir that practically they are the part of India, right? Because there was a lot of radicalism going on in that area, so it was a kind of message and an attempt to promote inclusiveness in that area. I will consider Article 370 or removal of Article 370 as an attempt to make Jammu and Kashmir more inclusive into India, right? Yeah. Any other questions still? See, why has two questions. So if you can ask the motive, that's another thing, right? So what was it legal, okay, or was it constitutional is another question, right? So if you're asking about the constitutionality of this complete process, I will say again that it was constitutional because you will see that Article 2 of Indian Constitution allows for admitting new state, and then when you talk about Article 3, where you talk about how a state can be reorganized, okay, how its boundaries can be changed, then Article 3 clearly spells that you do not require the permission of the legislative assembly of a state, okay, to approve for any reorganization, right? So Article 370 removal was a kind of a step or initiation after Article 3 was used, right? So when Article 3 is used, there is a term that any consequential changes when Article 3 is used, okay, will not require Article 378 or will not require a special majority or a special majority with ratification, right? So under those provisions, you can use Article 3, and then provisions which automatically gets affected due to using of Article 3 can be used to justify the process which was done by the government last year. Right? Any other question? AS Gaur, Rashid, any other? None, right? So we will meet tomorrow at the same time at 7 p.m. See you again. Okay, we will meet with a new topic and then we will discuss further. Right? Okay. Have a nice day. Take care. Bye bye.
Thank you, sir.
Thank you. Good day.
Good.